Hi there, my name is Samra A. Stevenson, and I am the owner and operator of S.A. Stevenson Law Offices, Office Without Walls, and Wills on Wheels Incorporated. I've been practicing in Maryland for about 10 years, and my practice areas focus on estates and trust, probate law, family law, and business planning. Now, today I'm talking to you a little bit about estate planning, which I would really like to term life planning for what it really does, and all the different elements that go into it and why those things are applicable to you. So I'll start off with talking about probate. A lot of times I get people in my office asking how they can avoid probate. Let me create a trust so I can avoid probate. I find this is a great place to start in terms of helping people understand what the estate planning or the life planning process is and why it's important. So let's talk about probate. Probate is the process by which the courts retitle, tax, and distribute your assets after you have passed away. The probate process takes approximately 12 to 18 months to complete, and sometimes can take longer, or with a smaller estate can take significantly a shorter period of time. However, you won't know what category your estate falls in, unfortunately, until the time that you pass away. So, what do people mean when they say they would like to avoid probate? Well, let me start off by telling you that nobody avoids probate. The only way to avoid probate fully is not to die, because as I explained to you previously, it's the process by which the courts deal with the assets or your belongings after the time that you've passed away. So, what are the different things that you need to think about when it comes to your life planning? First and foremost is, have you created a will? A last will and testament is what it's called. And usually the person that is drafting the will is referred to as a testator or a testatrix, depending if you're a man or a woman. Now, if you die or you pass away without a will in place, you're said to have died intestate, meaning without a will, you did not state anything, you did not serve it as a testator and create a will or a testatrix, and you've died intestate. If you die intestate, what that means for you is that the intestacy laws in the state in which you passed away will be imposed to determine how to distribute, tax, and deal with the assets that you've left behind. The intestacy laws are very clear, but they're unique to each state. In Maryland, for example, if you were to pass away without a spouse but with children, everything gets left to your children. If you pass away with no children and a spouse, everything goes to your spouse. For a more detailed explanation of the intestacy laws, I would encourage you to consult with an attorney. There are all different variations of how people can pass away and their arrangements with their families, and there's something that applies to everybody. Now, if you don't wish to see your assets distributed in accordance with the intestacy laws, the best thing for you to do is create a last will and testament. That's the only thing for you to do, is create a last will and testament, and I would encourage you to see an attorney about doing that. A last will and testament allows you to give directives to your loved ones and to the court about what you would like to see happen. Why is that important? Well, it's part of your life planning. It's part of, deciding where things are going to go. And more importantly, it takes care of the people that you are leaving things to and protects them against a complicated, drawn out, and expensive process after the time that you've passed. One of the things that comes up often are gifts to minor children. If you're leaving things to your minor children, do not rely on the intestacy laws to take effect. The best thing you can do is create a last will and testament spelling out how you would like things left to your children and who should take care of them while they are still minors. That's right, you cannot leave anything to a minor child. By law, they will take possession or ownership of the distributions that you've left at the age of 18. But prior to that, they cannot take. What will happen if you pass away and you've not left directives for what happens to gifts to your minor children is that the court will impose a trustee, and that trustee will oversee those assets, the distribution of those assets and the maintenance of those assets. But they will do so for a fee, which will cut into any of the gifts you've left behind for any minor children, which is probably not the goal that you had in mind. Now, the trustee is overseeing what's called a trust, which leads me to talk about exactly that, trust. What is a trust and why do you need one? There are several different types of trusts. The two I'll talk about today are a testamentary trust or a springing trust and a revocable trust. Let's start with the testamentary trust because that takes right off of the conversation about last will and testaments. A testamentary trust doesn't exist at the time that you're living. It is actual language, testamentary, that goes into your will, which spells out that you are requesting that a trust be created for the benefit of whatever minors or sometimes adults that you might be leaving things to. I like to refer to this as a springing trust because it's exactly what it sounds like. It springs up in the event that something happens. So in the event that you pass away and the person that you are gifting things to has not reached a set age, a trust would then be created. It does have to be created after the time of your death, and there is an expense involved with that, so you should consider that. But by spelling that out in your will, you can also give directives to who you would like to serve as a trustee, the person overseeing, using their discretion about whether or not those gifts should be distributed at whatever time. And you can be creative and as however you want to be with the language of that springing trust. For example, what I usually encourage my clients to do is not to leave anything to a minor before they turn 22. 22 is, the youngest that I would really advise somebody to do that. I usually ask people to start with age 25. But I've had clients ask that the language in their testamentary trust read, my children shall not inherit said gift, said cash gift, said car, said house, unless they are living a godly life. I had them spell out what godly life meant because I didn't think it was up to me to define that. But I only use that as an example to tell you just how much control you have with regards to putting some parameters around distributions of assets after the time that you pass. So that's a testamentary trust or a springing trust. The next type of trust I would like to talk about is a revocable trust. Now, this is the type of trust that people are asking me about when they come to my office and are asking to avoid probate. And let me explain what they mean by that, or what I explain to them that they mean by that. Really what they're saying is they're trying to avoid probate by having their assets not go through the probate process. So, a revocable trust, which is also complementary to an irrevocable trust, but I'm not going to touch on that today. A revocable trust is an actual living, breathing thing at the time that you're still here. So I usually refer to it as like a lockbox, and it'll appear in different attorneys do it differently. We create binders, and that lockbox is what is going to house your assets or protect your assets. Okay, and so what we do when we create that revocable trust is we retitle assets into the name of that trust. And so those assets don't have to go through the probate process, because when those assets are retitled, you no longer need to sign your name transferring them to somebody, or the court doesn't need to be involved doing that. And they can pass down to your loved ones, your heirs, anybody caring for your children, without having to go through that process. They take immediate control of those assets. So it's not really avoiding probate as much as it's like sidestepping probate. And that's called a revocable trust. There's also something called an irrevocable trust, which I've already said twice I wasn't going to talk about, but I'll just say enough to say that it changes the protections, liabilities, those types of things that are involved with maintaining the trust. If you have more questions about revocable versus irrevocable trust and what the pros and cons are to either, I would encourage you to consult an attorney. Feel free to call us at S.A. Stevenson Law Offices, for example. All right, so we've talked about wills. We've talked about trusts. What are the other elements of life planning? And this is why I don't refer to it as estate planning. Life planning involves planning for while we're still here as well. So ancillary documents touch on those. If you hear an attorney talking about ancillary documents, what they're really talking about are your power of attorney, medical advance directive, your living will, and something that we do at my office called kids protection plans. But let's talk about the first three first. Your durable power of attorney. Your durable power of attorney is a document that grants powers to an agent who you name to act on your behalf while you're still living with regards to your finances, your business, or any of those other tangible personal property issues that require your direct attention or signature. By bestowing powers on your agent, in the event that you are incapacitated or somehow otherwise unable to act for yourself, your agent can step in and act for you. Now, this is a living, breathing document unless you put parameters around what it takes for your agent to step in. For example, getting a physician to sign off on the fact that you actually are incapacitated. And I can talk a little bit more about that later, but I would also encourage you to consult an attorney if you have concerns like that, because that's a very delicate issue. It grants your agent the power to act on your behalf if you are incapacitated, and they can do so immediately once the document is signed unless you put those other parameters in place. In a similar way, a medical advance directive also grants powers to an agent, but to act on your behalf with regards to your medical care specifically. You can put the same parameters in place with regards to your medical advance directive, making sure a physician signs off on the fact that you're actually incapacitated. And on a side note, medical advance directives are a great way to deal with more complicated guardianship issues if those are something that your attention is piqued to. I encourage you to consult an attorney with regards to your medical advance directive. Two things about medical advance directives that I want to point out are, first of all, we're living in a different time right now, a time during COVID, and right now family members are not being admitted into hospitals with their loved ones. Why is that important with regards to your medical advance directive? Because you want to address that in the language of your medical advance directive. Maybe you already have one, and that's part of the reason why I'm saying this. This is life planning. Life has changed now. It might be time to pick up that document, address it, and make sure that it speaks to your agent's ability to communicate remotely. If you're not sure what that should sound like, talk to an attorney. It's imperative. Your medical advance directive agent is your last advocate for your medical health. And during a time right now where people are panicked and people are rushed and hospital policies are different, you want to make sure you're addressing your agent's ability to act on your behalf. Number two, don't think that medical advance directives are limited to older persons. Do you have any college-age students or college-age children? Now, a lot of children are at homeschooling right now, but do you have any college-age children who might be going away or who have gone away? Have you ever considered the headache or the frustration that would be involved if your college-age, over the 18 adult child were somehow in the hospital and unable to communicate for themselves? A medical advance directive would address some of those issues with regards to your access to medical records and your ability to care for your child in those circumstances. Sometimes people don't think about those a lot. Now, I mentioned kids protection plans a little while ago. Kids protection plans in our office are standalone guardianship documents, which leads me to my next conversation about guardianship, which is also very important. Standalone guardianship documents are important as part of your life planning, not estate planning, your life planning, because they speak to what you want to have happen with your family with regards to any minor children in the event that you don't make it home. Our kids protection plans include temporary and long-term guardian selections, medical advance directives for kids in case a temporary guardian needs to take that child to the hospital before any of the necessary legal actions have taken place that would allow them to do that. Instructions to caregivers, instructions to guardians, and ID cards to carry on the children's person and your person at all times. Now, standalone guardianship documents are important because guardianship comes up outside of the context of when someone passes away. And if you're waiting, or sometimes when people are only thinking about it, putting it in their will, in the event that they haven't actually passed away, others aren't thinking to look there with regards to what their wishes are on a temporary basis, for example. When choosing guardians for your minor children, you want to keep a few things in mind. And one of those is that your guardian is not your trustee. So this is not the person overseeing the money or what happens with any assets you left behind, but it's the person who's actually instilling values and creating structure and meaningful connections with your minor child. So choose a guardian who you think is uniquely suited for that. Leave the trustee in place with regards to the money. They don't have to be the same, okay? With choosing a guardian, sometimes people get tripped up on this. The most encouraging thing I can say to you is that almost anybody you pick is better than the state. It's better than Child Protective Services. It's better than them going to the ward. It's better than the other options if you don't spell out who you would wish to assume guardianship of your child. Keep in mind that your wishes as to guardianship are just that, they are wishes. With regards to who actually gets custody of your children, that has to be determined by the court. But if you don't put anything in place, you have no word in that courtroom if the process ends up happening with some sort of custody litigation. Your only word is going to be with what you've left behind, stating what your preference is. Just as important as your preference is any non-preference or anybody you don't want to see the children with. Now, let's say you've stated your preferences. Go the extra mile and state anybody you don't want to have them to, because in the event that your preferred person isn't available or does not want to assume responsibility, and somebody else, a third party, is making a determination, you want to make sure your word, your voice is heard with regards to what your wishes are with who should not take the children as well. So to briefly recap on what we've talked about today, we started off talking about the probate process and what that means for you. Probate is the process by which the courts retitle, distribute, and tax your assets. Remember, if you were to here to sign on that dotted line transferring that property, the probate court would not be necessary, which is why people create revocable trusts to retitle their assets into the name of a trust and, remember, sidestep the probate process. We also talked about ancillary documents like power of attorney, medical events directive, and living wills. And that's part of your life planning. Remember, this isn't estate planning, it's life planning. You're planning for all the unforeseen circumstances that might come up during your lifetime. And those ancillary documents are applicable to while you are still living and breathing. They are granting powers to agents to act on your behalf and make sure your affairs are taken care of, thereby avoiding expensive and lengthy processes to do so in the event of an emergency. We've talked about guardianship and standalone guardianship documents and why those are important to you. And we also talked about springing trusts and leaving gifts to minors. I hope all of that information has been helpful to you. If you have any further questions, feel free to reach out to us at S.A. Stevenson Law Offices. My information is available at the bottom of the screen right here. And I look forward to hearing from any of you. Have a great day.